The Good Black, a true story of race in America, tells the story of attorney Larry Mungeon, who sued his law firm for racial discrimination after suffering what he felt was unfair treatment. Author Paul Barrett was Mr. Mungeon's roommate at Harvard University and is a reporter for the Wall Street Journal. He spoke at the New York City Bar Association in April for 50 minutes.
Good afternoon. I'd like to welcome you here to the Bar Association of the City of New York, Books at the Bar Committee. My name is Tom McInerney, and I'm incoming chair of the Books at the Bar Committee. We're honored today to have Paul Barrett here to speak on his recent book, The Good Black, A True Story of Race in America. I'd also like to welcome C-SPAN, which is taping today's presentation. One story about racism in America holds that the civil rights era virtually ended it. Through social progress and legal reform, we had eliminated blatant discrimination from society. An alternative story, epitomized by books like Dinesh D'Souza's The End of Racism, denied that race even mattered anymore. From either perspective, Americans of many different backgrounds agreed that the ugly chapter of racism in American life was over. We had become the inclusive republic that we had always known we were supposed to be. It's safe to say that within the legal profession, the belief in an end to racial injustice was equally prevalent. Lawyers placing faith in laws such as the Civil Rights Act of 1964 believed that intentional discrimination and overt racism had become things of the past. Who in their right mind would discriminate against an employee? You'd get sued. That threat, more than any other, would ultimately deter racist conduct, or so we hoped. Unfortunately, our collective experience has shattered these beliefs. Louima, Diallo, King, these names, immediately recognizable, crystallize the state of racial injustice in America and force the thoughtful among us to wonder, how far have we really come? In some ways, Paul Barrett's The Good Black sounds a similar alarm. With his attack on the legal establishment, Barrett strikes a life-threatening blow to our complacency and shows the pernicious, slippery, devious ways in which racism can still function unfettered in spite of the law. Having found the loopholes in the protections of formal equality under the civil rights laws, employers, including lawyers, have learned to discriminate better, that is, more carefully than in the past. By exposing these holes, Barrett shows the need for additional reforms. Ladies and gentlemen, I'd like to welcome Paul Barrett, author, lawyer, Pulitzer Prize winner, and Wall Street Journal reporter.
We'll have to immediately back off of the Pulitzer Prize, which I would love to have won, but haven't. I was once nominated, but there's a little bit of a difference. Nevertheless, Tom, I admire your spirit. And should put you in touch with my mom, who has similar inclinations. Of course, the substance of Tom's introduction was very much on the mark. And I would commend, just to underscore the point he was making, this morning's Wall Street Journal, where I have my day job. My colleague Scott McCartney has a piece about American Airlines, where a worker in an American Airlines subsidiary facility was subjected over a period of time to racist graffiti. McCartney describes how in the certain area of this hangar, it was kind of like an evolving piece of modern art, because as workers would scrawl graffiti, management would come in and paint over it in one little square. The next day there'd be more racial epithets painted. They'd come in and paint over another, so that this piece of art was moving all around. But it was a very dramatic image of just how persistent the white employees here were to harass this fellow. Other aspects of their tomfoolery included the appearance of a gorilla dummy with a noose around his neck and the name of the black employee across it. So the point is that race is still very much with us. It's foolish to say we haven't made huge progress. We have made huge progress. But our tendency to single people out and push them away based on the color of their skin is still quite strong. The story that I tell in my book, The Good Black, is a very different kind of story. Larry Mungin, the subject of the book, was not subjected to racial epithets scrawled in the men's room of the law firm he worked at. No one called him any nasty names. There was no noose hung from a clock as there was in the American Airlines case, apparently. And I think that it's all the more important because of that. Because it's harder to pick up what was going wrong and what it had to do with race, I think it makes it all the more important for people to understand, because I think the arena has shifted, the tendencies have shifted, and certainly in white-collar America, the type of behavior that remains a problem for so many people is often very subtle and can be described in tones of gray, not black and white. Let me tell you a little bit about Mungin's story. In a lot of ways, Larry Mungin was an all-American success story. He was raised here in New York in the Bedford-Stuyvesant section of Brooklyn, and later in Queens in public housing. Came from a poor but not destitute background. By dint of hard work and a very persistent mother, he was propelled toward Harvard College, a distinguished career in the United States Navy, and then on to Harvard Law School. From there, he went to Houston, where he worked for several years in the Houston office, the then new Houston office of Weil, Gottschall, and Manges. Eventually, he ended up, for a variety of reasons, moving to Washington, D.C., and in the office there of Catton, Muchin, and Zavis, a large Chicago law firm that at the time was expanding its Washington office, as many law firms were expanding in the early 1990s. And that's when things began to go wrong for the first time in his career. The body of work that he was specifically hired to do evaporated. That was no fault necessarily. That was not connected necessarily to race, but rather than grapple with this situation, the law firm basically pushed Mungin away and treated him as if he was radioactive. He was given extremely simple work far below his level of expertise. He was left out of meetings, denied access to clients, and ultimately, and most importantly, the evaluation process and the promotion process were done without his name ever even coming up. It wasn't a question of his being passed over. It was a question of his never being considered in the first place. And that became Mungin's main complaint, that he basically, to refer to the title of the famous book, he became the invisible man in this office. People forgot about him. Meetings were held, social events were held, and for one reason or another, he was always missing. He was, by the way, the one black lawyer in the otherwise all-white 50-lawyer office in Washington. Now, there was a question. Was this a function of bad luck, of bad management on the firm's behalf, or did race play some role, or a predominant role, in the collapse of his career? Many people would have walked away from this situation, people who had been in Mungin's shoes, and I think that would have been a very rational reaction to the situation. If he had asked me at the time, that's what I would have suggested to him that he do. But for a variety of reasons, I think many of them more personal than professional, he decided that he was going to take this fight on. He was someone who, for his entire life, had bent over backwards, as he saw it, to accommodate white people, to reassure white people that he was not there to challenge them, to be the source of problems. And I think over a long period of time, that experience and the frustration that came along with it had built up in the man. He had struggled for a long time, in his words, to try to prove to people that he was the good black, thus the title of the book. And when an employer really broke the bargain that had struck with him, mistreated him as he saw it, for reasons, he couldn't see any reasons other than the fact that he was the one black attorney in the office. He decided to fight rather than to compromise or to walk away. And the law firm basically said, fine, then we'll fight. There was very little effort to settle the matter because the law firm was just as passionately convinced that it had done nothing wrong. I've been asked quite a bit why I decided to write a book about this story, particularly since it isn't a dramatic story of the sort that we were talking about earlier. And there are several reasons. For one thing, the case ended up in court. There actually was a trial, a very unusual trial. Very few people, very few lawyers sue large law firms for race discrimination. If you go looking in the law books for such cases, you won't find many. And there's a simple reason for that. It's not a very likely target to take on, a large law firm full of lawyers who are skilled at fending off such attacks. It was a very unusual opportunity to look behind the scenes at an institution like this. The lawsuit generated a lot of information that often is not available to the public. It became available in this situation, and I thought that aspect of the story would be of considerable interest to many people. I also had a very personal motivation for wanting to write this story. Mungeon had been my law school roommate our first year at Harvard Law School. I had been talking to him about his dreams and his aspirations, his professional goals, his personal goals, for some 15 years as this trial began to unfold. To me, it was a mystery and a tragedy that someone who I thought of as absolutely destined for success, someone who I thought of as integration personified, had ended up in a racial discrimination lawsuit, ironically, wrapping himself up with the issue of race in a way that he may never be able to disentangle himself. I wanted to figure out how that happened, how the person who I knew had gotten to that pass. I wanted to find out how a law firm would end up at war with such an attorney rather than embracing him. While the suit was very much unusual, another reason for writing the book was that the experiences that Mungeon had, I think, are not at all unusual. I think they're quite typical for black employees in white-collar workplaces and for middle-class blacks in general in our country today. In reaction to the book over the last 3 months, I have had literally dozens of black employees from the securities industry, from law firms, from accounting firms, from big industrial corporations, from high-tech companies contact me and say in one way or another, aspects of Mungeon's story are part of my story. And this was what I suspected based on my non-scientific reporting, and I think it's been proved, not scientifically, but at least anecdotally, that the frustration he felt, the subtle exclusion that he underwent, I think is very typical, and I hoped that telling the story would bring that to light in a way that would allow people to understand it and accept it. I tried to tell a story in a kind of even-handed way, not as a polemic, but simply telling the facts, leaving readers enough room to come to their own conclusions as to why the facts had played out the way they did. A way of capturing the situation we're at that I think is helpful and that I refer to in the book has been discussed by the sociologist Orlando Patterson at Harvard, who has written about what he calls the paradox of integration, the strange phenomenon that as we end up closer together, working cubicle by cubicle on the same hallway, new problems of race relations arise, such that people are sometimes under the impression that things are actually getting worse now that we're together. And I'm sure you all have seen arguments to this effect, that as bad as segregation was, at least there was a sense of solidarity in the black community, would be one form of that argument. Though we've made some progress, we don't have the feeling of forward momentum that was felt in the 60s and the 70s. I think all of these things are, in a sense, true, but shouldn't be accepted without further thought. We have made this progress. Larry Mungeon was working in those law firms. Law firms, to some degree, are integrated today, and yet there is a great deal of low-level, often unexpressed resentment and feeling of exclusion. And I think that paradox of integration is something that people would profit from analyzing in their own lives, their own workplaces, and it's one of the themes of the book. That brings me to a series of just brief observations I want to make about aspects of the story, and then I'd be very glad to answer your questions. My first observation is an elaboration on the last point. The clothes do not make the man. I think it is very common for people to allow themselves to forget that if colleagues come to work more or less dressed the way they're dressed, with the same academic credentials that they have, maybe even living in the same types of suburban communities, that those persons have all the same experiences. And I think that often is simply not the case. In The Good Black, I just try to describe how Mungeon, going back to childhood, had absorbed a series of slights ranging from flat out being referred to as a nigger at Harvard College when he was a freshman, behind his back, but an experience that prompted him to wonder, I wonder how often people refer to me that way behind my back and what they mean by it when they do, that I'm stupid, that I'm unsophisticated, and that people are doing that at Harvard. When you have those experiences, no one of which may have stopped you even for a day, and then you come to a situation in a law firm or at some other place of employment where you begin to suspect that your race is contributing to some sort of difficulty, you're going to have a very different reaction to it than someone who looks more like me, who may encounter the same type of apparent difficulties, but will not have been conditioned over time to be very suspicious as to whether such problems have something to do with their skin pigment. Another thought is to try trading places. Mungeon worked in an office where he was the one black lawyer working with 49 white lawyers. Some people in reading the book have wondered, well, why did he begin to think that race had something to do with it? Why did he go in that direction? And one way to answer that question would be to play the game of imagination, of imagining that you're the one lawyer of your race, say white, in a lawyer with 49 black lawyers, and things begin to go mysteriously sort of wrong with your career, and to wonder whether the idea might not occur to you that race might have something to do with it at some level. That experience is not that unusual for black professionals and is another component of that paradox of integration that I mentioned earlier. My third thought is that it's not really about the money in a lot of ways. Money comes up a lot in this book. Mungeon complained in his lawsuit about his salary as he entered the law firm, showing that he was paid slightly less than other lawyers of similar experience, that he was denied a key raise at a certain point. And obviously, eventually, he made a demand for damages, quite a large amount of money. But I am convinced that it wasn't the dollars that drove him to file this lawsuit. I'm convinced it was the law firm's refusal, once everything collapsed and things had gone very bad, refusal to sit down with him and say, how can we make this at least partly right so that we can part company in a kind of civilized, straight-up way. And instead, there was a kind of vague series of offers and counter-offers, all of which struck Mungeon as basically counterfeit, and eventually he left and sued. A fourth thought is that some things that appear to be just very much trivial slights can in fact cut deeply when they accumulate, when there are many of them, and when they fit a pattern in a black employee's life outside the law firm, and maybe even in the years before he or she was a lawyer. In the book, I describe an instance where Mungeon, who had been pestering the two most senior lawyers in the Washington office of the firm to involve him in more client marketing activities and just to involve him in more remunerative work, at the very last minute is told, hurry up, get your coat on, we're going to a marketing seminar. And he, at first, was pleased to be invited along, although somewhat confused as to why it would be as such at the last minute. He would be expected to provide some type of presentation on bankruptcy law, which was his area. One would think that he would be given at least overnight to decide what to say. And then the senior lawyer said to him, by the way, grab that projector there. We need to bring that with us. Apparently the hotel was not providing a projector. And as he was carrying the projector down and putting it in the cab, and then later when he saw that his role at this thing was really completely an afterthought, that there wasn't much that they really needed him to do except to carry the projector back to the cab after it was over, it occurred to me, well, maybe they asked me to come along to carry the projector, which may not be that big a deal if you were, say, a first-year associate. Certainly not if you were a legal assistant. But if you were a 6th or 7th year associate, as he was, he took this as a slight. Like, this is how I'm thought of here, as the kind of guy who's around to carry things. Again, not something you'd file a lawsuit in federal court over, but if that goes along with a lot of similar experiences, for example, the law firm has a big kind of ceremonial lunch in honor of a visiting Italian jurist who they are trying to woo because they're trying to generate some business in Italy, where they have a one-lawyer outpost. Mungin, as it happens, is the one lawyer in the office who speaks Italian. He's a very talented guy. He spoke Russian as well, which he learned in the Navy in connection with becoming a code breaker on submarines. He spoke Italian. He was always talking about things Italian. And when he heard about this lunch, he thought this was terrific. I'm going to be the star of this lunch, obviously. I mean, I'm the guy who's going to translate. And he wasn't invited. And minutes before the lunch began, he sort of stepped forward and said, well, am I not coming to this lunch? Oh, yeah, sure, come along. But the fact that, again, that other people were invited by name, and not the whole 50-lawyer firm was not going, and he wasn't, struck him as very odd. That doesn't sound like old-fashioned discrimination. It sounds more like an absence of thought. And experiences like that, the projector anecdote, the lunch invitation that didn't materialize, begin to accumulate. Another thought. No, black lawyers are not grateful just to have the job. I present a couple of instances in the case where senior people at this firm said to Mungin, more or less, what are you so upset about that your career is not going well? You have a job. They literally said that flat out to him. One lawyer over lunch, where he was pestering her, trying to figure out who would be looking after his promotion, said to him, you have a paycheck, you have no wife, no kids, what's the problem? The problem was that he wanted to advance just like anybody else in the law firm wanted to advance. And it took a couple of years for him to realize that that actually surprised people in the firm. That it hadn't, I think, occurred to them that he wouldn't just want to pull a salary, but he had joined the firm to move up the ladder like other people in the firm. Another thought is to save your favors. There was a considerable testimony at the trial, both deposition testimony and on the bench, on the stand, from Kattenmuchen lawyers who emphasized that they had done many things to try to, in their words, save Mungin when things went wrong. Among the steps that were taken were providing him with work that everyone agreed was first or second year associate work, just so he could continue to bill hours. Also his fee being reduced from $185 an hour to $125 an hour. These were gestures that the law firm tried with a straight face at the trial to present as their efforts to save Mungin. Well, clearly favors like that are doing nothing for anyone's career. If at a large corporate law firm your billing rate is going in reverse, you're not headed toward anything worth going for. And doing first-year associate work clearly is worse than just been leaving altogether. And I think that this type of gesture is often tried and usually backfires and can later cause a lot of harm. Finally, think twice about what I think of as the equal opportunity bastard defense. One of the main arguments the law firm made at trial was, yes, Mungin had a pretty bad time. They conceded that. But we gave a lot of people a really bad time in this office. White, black, didn't make any difference. We were screwing everybody. We're just bad managers. That's the way we are. Which is very similar to what Washington lawyers are familiar with as the defense contractor defense. Sure, we padded the budget on the bomber. That's just the way we do things in our industry. That type of argument may actually be appealing as a logical matter to lawyers, but I can tell you that it doesn't appeal much to lay people who are basically trying to sort out who's who's the good and fair person in this type of dispute and who's the person who's doing wrong. And it certainly didn't appeal to the jurors in this case. What I think would be good would be if I were to now allow you to ask questions. I haven't told you where the case ended up. I always try to resist doing that, but if you force me to, I will. There was a trial and there was an appeal, and it was all quite interesting. And I think if you would, our friends from C-SPAN would like to put a microphone near you as you ask a question, so if I ask you to ask your question, wait a moment or two until C-SPAN gets to you.
I am interested in how it came out in the reverse
So,
I understand
right.
if you want to talk about it. I'm also interested in what did the law firm say was their motivation in hiring him? Was he the first black that they'd ever had as a lawyer? And what did they, was it testimony about that?
Yeah, why don't we start with that first and then the legal story. No, the law firm had hired black attorneys in their Chicago office. At the time he was hired, Mungin was, as I said, the only black attorney in their Washington office, and that was a source of embarrassment at the firm to have no black attorneys in a predominantly black city. That was considered, his race was seen as being an advantage when he was hired, but also they had the idea that they were going to build a bankruptcy practice attached to an insurance defense practice. Out of Washington, they represented large insurance companies. The insurance companies had insureds who were going bankrupt, and they wanted to have a real bankruptcy team that could jump into those cases to represent the interests of the insurance company. That's the purpose he was hired for primarily. The case went to trial in March of '96. It was heard by a jury of 8 in federal court in Washington, D.C. The jury was predominantly working class, 7 black jurors, 1 white. After a week-long trial in which the law firm was kind of in the alternative arguing, we're terrific, we helped him, and if you don't believe that, we were screwing everybody, so he wasn't special. The jury took about 2.5 hours, which, as I understand it, included lunch, to decide that Mungin had in fact been discriminated against, treated differently from other similarly situated associates. He was awarded $1 million in compensatory damages and $1.5 million in punitive damages, $2.5 million total. The largest such award I could find, won by an attorney. As I said, there are very few such cases out there. The firm never gave an inch, said that the jury just misunderstood the facts, immediately appealed, and about a year later, a 3-judge panel of the Federal Appeals Court in Washington reversed the case in its entirety. The ruling on appeal was split along racial lines. 2 white Republican judges said that there was simply an insufficiency of evidence to find discrimination, an unusual ground for reversal in a Title VII case. No legal basis beyond that. Simply the facts aren't there. There wasn't one scintilla of evidence of discrimination. The black chief judge, Harry Edwards, who was the 3rd member of the panel, concurred in one small part of the finding, that having to do with Mungin's allegation that he was effectively fired. Edwards agreed that he wasn't effectively fired, but said that he would have left in place the main part of the verdict, the discrimination finding, and would have sent the case back to the trial judge for a recalculation of the damages, obviously a reduction of the damages. Edwards described the case as presenting what he called a close question, but one that was fully within the jury's grasp to decide. The trial judge, many people are curious who the trial judge was. Was it a black trial judge? I've been asked impatiently on many occasions, and no, happens to have been a white trial judge, a guy who had been a partner for some 25 years in a big corporate law firm in Washington, D.C., the Wilmer, Cutler, and Pickering firm. Yes, sir.
I was wondering if you might engage in some comparative generalizations between the large law firm environment and the large corporation environment in the states. I had the opportunity not long ago to be involved in the Texaco case, and what I was struck by, notwithstanding a lot of public reports to the contrary, was that even at Texaco, there was a very entrenched process of employee review, which was explicitly encouraging minority advancement, which was designed, however imperfectly, to do that, to bring in diversity trainers.
I see where you're headed, and I agree with you completely. While generalizations are always dangerous in this area, as in any area, I think it's fair to say that the lawyers in this regard are worse than their clients. I think law firms have much murkier ways of bringing people up through the system, much harder to identify structures, much more revolves around very subjective appraisals that are frequently not even committed to paper at all. And many, if not all, big corporations have structures that are at least a step in the right direction, even if, as you say, they are quite imperfect. And in my totally unscientific experience writing about these issues, my impression has been that at least in corporations, you can have some sense of where the structure is, and so that if you want to climb, you may know where to begin to climb, whereas in law firms, it's a lot murkier for everybody, but perhaps disproportionately more difficult to find your way for a black associate who doesn't see people who have shared his or her experiences and doesn't experience people holding out that critical hand saying, here, let me show you, let me go out of my way to pull you up a little bit, which in the end is the critical event. You're not going to succeed in a big law firm, certainly, unless some partner at some point says, let me do something beyond what I have to do to help pull you up. I mean, that's the way white lawyers advance, that's the way black lawyers advance. The problem is going to be, will come in when a very understandable phenomenon sets in, and that is we tend to reach out to people who remind us of ourselves 20 years ago. That young fella is just like me 20 years ago. I'm going to give him a hand. You may not say those words to yourself, but I think that's very, very common. I certainly have observed it where I work. I certainly have felt it myself. And if someone doesn't resemble you 20 years ago, you're not necessarily going to try to do them harm, but I think you're going to be much less likely to make that extra effort that you don't have to make to pull them up the ladder.
I was very interested in the treatment of law firm employees generally, not just the racial aspect. And I was very concerned that the way Larry Mungin was treated in the law firm was indicative of a decline of civility, if there ever was any, in the way law firms treat their employees of all sorts. And that, to me, was perhaps the most telling aspect. Whether they're laying off employees and saying it's for quality reasons rather than for economic reasons, or a whole host of things, or the way they treat each other on partnership time, I think that's an area that needs to be looked at.
I think there's much to what you're saying. My guess is you're a better authority than I am on that subject, but certainly I do write about law firms from time to time for the Wall Street Journal, and it's my strong impression that as the size of law firms has increased, law firms are bigger, more corporate type, corporate in the sense of just size, institutions where even all the partners don't necessarily know each other, let alone know the associates. In the last 10, 15 years, law firms have just explicitly acknowledged that the bottom line is the most important issue, that they're businesses like other businesses, and as those types of attitudes set in, attitudes I'm not condemning or praising, I think you're going to have less of what you refer to as the traditional civility in law firms. But I'll throw another suggestion on the table, which is that, again, as law firms become more diverse, as different sorts of people end up in law firms with different attitudes and different experiences that come with them as they walk in the door on the first day, it will be more difficult for law firms, for the situation to feel collegial, because we are no longer all very much the same in where we come from. And that doesn't contradict anything that you're saying. It's simply a multitude of difficulties law firms are going to have to grapple with. Yes, sir.
Hi, my question is, what was Larry Munnigan's response or reaction to the book, and also what is he doing now?
Larry devoted a lot of time to answering a lot of questions. That was not always a smooth process. You know, unleash me on anyone's life, and it can be a little bit annoying after a while. He was very, as I say, though, he was very generous. A part of the process was his reading the manuscript before I turned the final version into the publisher. He did not have any authority to reject it or veto it, but as part of our sort of informal understanding, it seemed to me to be very wise to let him take a look at it. He corrected a few names that I had garbled and got a few dates straight that I had managed to screw up, and otherwise he said that the book, though not the book he would have written, was fair, and I felt flattered for him to say that. In particular, he complimented my effort to describe his family as individuals apart from the legal story, and I was very gratified by his satisfaction on that score. What is he doing now? He is now a legal headhunter in Washington, D.C. He had worked as a contract lawyer until today. He signed a contract, he told me in an email, to go to work for a recruiting firm in Washington, D.C. So he has, at least for the moment, left the world of practicing law to gain his revenge on law firms in Washington. Ma'am, did you have a question? Oh, same question. All right. Do you want to wait until the fellow?
I guess a follow-up. What kind of book would he have written? Did he indicate that to you?
Oh, sure, yeah. No, he's not that shy about expressing his point of view. I think he would have made the legal story seem much clearer. I present this as a fairly murky story in the sense of whether Title VII of the Civil Rights Act was violated. To him, this was, as you might imagine, not such a murky question. And I think that some of the people who became his antagonists at the law firm might have been painted in slightly more menacing tones. And everyone has a different perspective on life. You learn that as a journalist after you put something in a newspaper and people call you up. I had to complain a little bit. So I think that's largely how it would have been different. I think he also might have put a little bit more first person, just kind of philosophizing about what all of this meant to him. My goal was to write a very trim, fast-moving book, and one where it was very explicit that the goal was to let the reader decide, as opposed to persuade the reader one way or the other. Yes, sir.
Did he ever indicate that if the offer to move to Chicago or New York had been made earlier, that that would have made a real difference?
Let me explain. That's a good question. At the end of the debacle, just before things totally collapsed, the law firm made at least a formal, if not necessarily a sincere effort, to have Larry come to either the home office in Chicago, where obviously they had a large, bustling practice, or the New York office, as they refer to it, which in fact, as was the case in the early 90s with many firms, was more of a facade. I mean, it was typically a one-person office just so they could say they had a New York office. The New York office came first. I think Larry viewed that as totally counterfeit, just to merely a ploy, so the letter would be written and be there as evidence if needed. Subsequently, when he turned that down, it occurred to them to invite him to Chicago, and I think in that order, he dismissed the Chicago offer as well. If that had come a year earlier, I think he would have considered it. He certainly was not someone who was averse to moving around the country. He had done it before. He had made a considerable effort to express the idea that he wanted to work for the firm. He was looking for bigger and better bankruptcy work. They had such work in Chicago. I think if a sincere effort had been made to involve him in the Chicago practice, he would have received that well. Yes, ma'am.
I was wondering if there's ever been any comparison to Mr. Mungin's case to Isolde v. Wolf Block, which was a case I worked on, which I think is still the only case where a female challenged a partnership decision. And it's similar in that both plaintiffs won at the district court level, although Isolde was a bench trial, and then lost at the appellate level with a very extensive review of the facts, which is odd at the appellate level. And I know in the Isolde case, the aftermath was that the judges were very uncomfortable second-guessing law firm decisions because it struck too close to home for them. I was wondering if there was a similar type of analysis in Mungin's decision.
No, I didn't make an explicit comparison between the two cases, but I think your comparison is quite apt. In the book, I wanted to make sure I was sending the signal that this was not a book exclusively for lawyers. But indirectly, I referred to that case because Cat and Muchin, in its appeal, invoked the Third Circuit's opinion in the case that you're referring to. And the piece of the argument from the Third Circuit that I put into the book, because I thought it really did capture the whole mood of this thing, was that the civil rights laws do not guarantee, not only do they not guarantee good behavior, they don't even guarantee fairness. And if you think they do, you are misguided. That was the Third Circuit's conclusion. And that was very much Cat and Muchin's argument. We were not obliged to be fair to this guy or to anybody. That's not what the civil rights laws are about. They're about very discreet mistreatment that is not being applied to similarly situated people. So the two cases, I think, are quite relevant, although they dealt with quite different plaintiffs. Yes, ma'am.
In the beginning, you mentioned that if Larry had asked you about bringing the litigation, you probably would have advised him against it.
Mm-hmm.
I wondered, after writing the book, would you still have advised him against bringing the litigation? And if not litigation, what are your thoughts on how do we solve this problem?
Yeah. Well, as the Third Circuit implies, life is not fair. And sometimes decent people get screwed. And it is not, in my eyes, it is not obvious that the thing to do is always to fight, because life is also short, as well as not being fair. If Larry had raised this with me, I would have told him, move on. Either move on to keep your law career together, because if you file a lawsuit against a big law firm, you're done in big-time corporate law, or move on to something outside of law, because you don't have to be a lawyer. Being trained as a lawyer is not a life sentence to practicing law. That's my inclination in life, but this whole experience signified something very different for him. He felt he had walked away from a lot of fights before without fighting, and he wasn't going to walk away from this fight. He wanted his day in court, and literally said that rather cliched statement, I want my day in court. It's also easy for me in retrospect to say I would have told him not to file a lawsuit when you see how hellacious the experience of filing a lawsuit is, but everyone here who's a litigator knows that it's no picnic to file a discrimination lawsuit. You are inviting your opponent to go through every aspect of your life and to find flaws in your character and so forth that weren't otherwise on the surface. Interestingly, they found no dirt about Larry, or at least they presented none at trial. That was quite striking to me, that as in most employment discrimination cases, the defendant will at least come up with the resume that someone lied on, or the form that they should have turned in but they kept squirreled away in their desk, or the expense account that they should have turned in that they never turned in. There was none of that in this case. I don't know whether that was whether they kept a lot of things back that were there, or whether, as Larry puts it, and I think he's within his rights to do so, there was no dirt on me.
You also put in the book that you traveled to South Carolina with Larry, and essentially put yourself in a situation where you're the only black in white in a black community. What was your?
For a few days, anyway.
Say it again.
For a few days, anyway.
Yeah. So I just want you to elaborate more on your experience going down there.
Well, it was a fabulous reporting experience. It's always good to, see something new. I was unfamiliar with that community on the Barrier Islands off Charleston and south of there. Those are unusual, somewhat isolated communities. Some of the older people there speak in a way that is not familiar. I mean, it's English, but it has a totally different cadence to it. And it was all learning. I mean, it was all, I was picking up the history of the region, I was picking up the history of his family. I was learning about things that he had never talked about, but which, by showing them to me, he could explain. I mean, I met friends of his father, a man from whom he was estranged for most of his life, but with whom he had a rather emotional reconciliation near the end of the father's life. The father died just before the trial, and this was a very important symbolic event to Larry, and Larry felt that his father's illness and death had drawn him to his extended family in South Carolina. And to see Larry in that context was important to me to understand him, because in many ways he was a very isolated person, a loner by his own description, and is today. But at least for some short period of time in that setting, he wasn't a loner. Everyone there knew him. If you're not a Mungeon on the island of Edisto, then you are a cousin of a Mungeon. That's an unusual, old-fashioned situation, one that I'm not much familiar with, so it was interesting. And it is also very striking to be in a Baptist church first built in 1812, being the one white person in the midst of a very rousing Sunday Baptist ceremony, and to see this guy who you think of as your admirable longtime law school friend, hardworking, somewhat kind of pent up and uptight kind of guy, stand up and without any notes deliver a 20-minute Sunday morning sermon about God has a plan with it for everyone. He had a plan for me, he has a plan for you. And he's quoting scripture, and there's no notes, and I'm saying, this is a different person. Where did this person come from? But of course not. It's the same person. It's a reminder that we all have different capacities in us that we call on and show and or keep to ourselves. So it was one of the most valuable aspects of the research of the book. Yeah. One more, okay. He wins.
If you were on the management committee of a large firm, what concrete steps would you recommend your firm take to address some of the issues you encountered, and specifically would they be directed at the sort of fairness issues across the board, regardless of race, or would you focus more on race-sensitive approaches?
Well, in terms of the formal things to be done, I would say those should be probably without reference to race. I mean, there should be a serious and rigorous evaluation process, one that's enforced for everybody, where everyone is told candidly, you tell me twice a year, 3 times a year, don't pretend to be a law firm management consultant, just how they're doing, how they're progressing, what they need to do better, where their flaws are. But if you have such a policy, you need to enforce it. At Cat and Muchin, at trial, Mungeon objected that he had never been seriously evaluated. And the firm put testimony on saying, yeah, we have a policy to do that, but you know, we never enforce that type of policy. But then on the issue of salary, when he complained that his salary came in lower than that of associates of similar seniority, they said, oh, well, that's because of the policy we have of when you come into the firm laterally, we split the difference between your old salary and where you should be in our firm to save a few $1,000s. That policy we always enforce, but the evaluation policy, we never enforce. Well, I mean, I think that's all too typical. If you're going to have policies, enforce them, and give people a sense that there's a structure, that there's rationality, that doesn't all depend on who you're friends with or whether you get taken along to the golf game. Now, I think beyond that, and I'm going to keep this brief because I don't like prescribing very much, but beyond that, I think law firms need to exhort the people who have authority, who already have power, who are secure, to reach the hand out, as I was saying earlier, to those associates, whoever they are, who are going to be more likely to be cast aside, who may not have the opportunity to show how good they are, because that's what you have to give people, not a right to be promoted. You have to give them a right to show you whether they should be promoted. They need to come to that meeting where they can dazzle the client with some great insight. If they're not at the meeting, they're never going to dazzle the client. If they're not put on the tough, interesting deal, no one's going to know whether they can handle the tough, interesting deal. So in terms of informal policy, I think at their partnership meetings, the law firm has got to, the partners have got to each look at each other and say, now, are we each doing what we know is the right thing? Are we each reaching out to 1 or 2, however big the law firm is, or 3 associates who seem not to be taking those quick steps up the ladder and giving them the opportunity to show us what they have. I mean, presumably they've got the basic stuff because we hired them in the first place. And we're not saying we're going to promote them all to partner, of course not. But we're going to give them a shot to see what they're capable of, as opposed to it being a kind of some Darwinian, every person for themselves, may the devil take the hindmost and the tough will survive. I'm not a believer in that. Some people run newspapers that way, but I'm not a believer in newspapers either. Thanks a lot for your time. I appreciate it.
There are books for sale outside. Just like Mr. Barrett, sign copy.
Paul Barrett covers legal affairs at the Wall Street Journal. His book, A Good Black, is published by Penguin Putnam.